we're going to go ahead and reconvene the meeting. I'm going to call the meeting back to order from our recess of February 25th, 2026. We'll open with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Need to ask everybody in attendance, did you sign in on the sheet? Okay, thank you. Again, if you're not familiar, the board members, myself, I'm Tony Volker, chairman, Mr. Frank Coughlin, he's our vice chair, Diane Stutzman is our secretary, and also the county clerk. Mr. Richard Lorenz is our counsel, and we are continuing our public hearing for our Can 1 challenge findings. Mr. Lorenz will open for us with a couple of statements, and then I'll be making a statement, and Mr. Coughlin will make a statement, and then we will get into the individual situations.
Thank you.
Thank you.
I thought I'd make some observations from our hearing yesterday. We took 5.5 hours of information and testimony from the various witnesses, and it deserves some comments, I believe. As I mentioned before, I've been working with the county government for 54 years and have been deeply involved in almost every office and committee and commission that we have in that term and all. In some ways, I know where all the skeletons are buried. In this regard, it is interesting to note that we have this universe of things that were challenged in this case, and it portends that there are a number of problems at different levels, which suggests that there is a sort of a systemic issue that probably needs to be addressed. And to that end, I have talked with the clerk, and I will give my after-action reports suggesting certain changes, I think, that we can make at the candidate level, at the clerk level, and at the party level, perhaps, to alleviate 90% of these particular problems and challenges we see here. The second thing is that if you probably put the microscope in the same manner that the challenger used in every office, there would probably be many similar challenges across every office in the entire county. And if you applied it across all 92 counties, you'd probably see the same phenomena. And frankly, we would be bogged down with nothing but these technical challenges as our everyday work. And there is many things that need to be done in addition to the election issues. So I give that as a context to where we are. The other thing is that I want to talk about forms. In the world today, forms have become the manner by which we gather information and organize how it is processed. And forms are very important in that regard, and the instructions are fairly clear in many cases about how they're to be filled out, but there can be some confusion, and human error does enter into the process. And I can tell you that we have gone from just a few forms to many forms and many different aspects of how those forms will be filled out. The complexity of the form filling out is identified by the fact there's 150 pages in the Indiana Candidate Guide. Okay, if the form is only 2 pages and it takes you 150 pages to explain all the details and ramifications, it is evidence there's a little bit more to this than might appear. The second thing is that there are some technical details that are involved in this process here. It's interesting to note that the challenges have been grouped, and you can see similarities between more than one person making the same error across the board, which is evidence that it is confusing to more than just one person. The other part of it is that some of these challenges are technically correct. They are statements of fact that in fact you will find on the forms or missing from the forms. The question becomes then, what is the remedy that is involved, okay? You have before you in the segment of the election candidate guide, pages 15 and 16, when the candidate filing must be rejected, and there are specific circumstances like that. It's interesting that it does not go beyond those particular, I think there are 9 items of reasons. So there appears to be something else that can be done in some cases, okay? So I'm going to go through a couple of things here. The part of the form that contains questions 7 through 13, it's in a box that is surrounded by a bold border, and it continues down the stream of questions, and at the very end of it, in that same box, is the certification and attestation of the quality and the truthfulness of those remarks, and it is signed at that point in time. There are places on the individual line items and elements that require a initialization, okay, and a checkbox to be exercised. Those particular items, those kinds of form additions, I call those embellishments, okay, because the form itself is still signed by that individual. And the embellishments that are not filled in are an attention-grabbing method of getting you to say, I realize that's true. If you look at the elements about what they're talking about, they're wanting the candidate, for example, to acknowledge that they are under the provision of the Indiana Code regarding the requirements for campaign finance reporting, and that they have to qualify for certain things in doing their job and in being able to perform their job. Those things are still required by Indiana law, and the signature at the bottom essentially is a confirmation that they understand it, whether they initialed it or not. An example I might give you would be, I think you have all possibly run into a mortgage situation or a will or some other insurance device at all, where you will see at the bottom of each page an opportunity to initial those things, to certify that page was a part of the entire entity and all. And yet, I don't find any cases that have thrown out those documents for their overall validity because they have failed to initial that particular element, okay? Now, these are matters, I cannot substitute my opinion about these for what you need to do on these matters. I'm just giving you context in which we're talking about these matters. There are obviously things that could have been done and should have been done better in these matters, and matters involving the campaign financial reports and all. The election laws are basically divided into 2 parts. One is the election and candidacy and the appropriate collection of that. And then subsequent to that, or in addition to that, is the campaign financing reporting. It appears that the legislature has given the campaign financing reporting element an entirely different thought process and an opportunity for review of those documents, even whether the candidate is successful or not. So that would appear that those elements that are involved in the challenges that have to do with the campaign financial reports and all could be the subject matter of a further review, and it may very well be that that should be done because you have candidates who have already advised you in open proceeding that they have certain mistakes or omissions that they may have made. So you have the power to set those as a separate matter, and as a result of those separate matters, hearings would be had, and the parties entitled to explain and show what is going on. And as a result of those, there could be sanctions for fine or other penalties, or even referral to other agencies. So you have those remedies available as well. So I just call those things to your attention. I have given you a sheet with each of the candidates that has been presented here and the challenges, and I've given you a universe of possible things to consider in deciding how you want to make your findings and conclusions of law. And the ultimate result is either a qualification or a disqualification resulting in their being either on the ballot or not. So you have those things in front of you, and I want to invite you to debate and determine how you feel you want to act on each of them individually. And then there is a signature block for the members to sign as to each one. Once we have come to a final determination, you have indicated to me where the final ones you want to have, we can make that into the finding of fact conclusions of law and publish those for the purpose of this meeting. This is a debate amongst the members itself. It does not involve the public itself, although the public should be aware of what's going on. We want to confirm that all the members have not conferred with each other since the meeting we had yesterday concluded or was recessed, and now you are going to be making your debates amongst yourself for the first time.
Thank you. Thank you for that information. It's very helpful. I concur. I discovered some of those exact same points as in my due diligence on this process. Two things. I want to make a general statement. First of all, Pam Rogers sent an email last night saying that I was wrong in my statement that we no longer have precincts because we're vote center. So technically she's correct. In terms of voting, we don't do it by precinct, we have vote centers. Where the confusion comes in is, I was looking at that particular candidate who lives in Franklin Township. In Franklin Township, we do not have a further division into precincts. So technically speaking, her form should have said Franklin, which is redundant and kind of silly in my opinion, but it is what it is. But if you're in Washington, for instance, it would be Washington 1, 2, 3, or 4. Or if you're in Clay, it would be Clay 1, 2, and so on and so forth. I think Wayne and maybe one other township that we have. So I will retract that statement because I made it very adamantly, and I want to retract that and say that it's kind of a mix between both, but I will concede that point because I don't want any confusion to be out there in future candidate forms. Secondly, several of the things that Mr. Lorenz shared, I came to the same conclusion in my reading of the law and the documents that we went through. I finished at 11 o'clock last night, so there is a lot of stuff that we had to consider. One thing I want to point out, though, is the law makes a pretty clear distinction in my reading of it. They make a big difference between, concerning campaign finance forms, a big difference between delinquent and defective. A delinquent form, they're much more adamant about assigning penalties to that, civil penalties, unless by unanimous vote of the board they choose to waive those penalties. Defective reports are treated much differently. Those typically say that they just give the candidate time to fix those, and after that certain amount of time, if they haven't fixed them, then they tend to go toward civil penalties. That's the way I will make most of my judgments today on all of those. Just putting that out there. So once we get into this is not open for public comment. It'll just be a debate, as Mr. Lorenz said, amongst the board members. So I also wanted to thank Mrs. Rogers because at the very least she has pointed out some systemic failures in our county, and I'm sure, and I agree with Mr. Lorenz, that this is probably statewide. But it is at the very least a good clarion call for us to be much more diligent and much more careful when we're filling out these forms, and much more pay much more attention to detail and seek counsel if something doesn't make sense to you, because these are legal forms and we do need to be very careful on how we fill them out. So in that sense, that was a good teachable moment for us. This whole process has been, as long and tedious as it is. With that, I'm going to turn it over to my counterpart, Frank Coffin, and let him do his opening statement before we get into the individual cases.
Thank you, Tony. I also concur with a lot of what I've heard, which is here already this morning, which is, I hope, a good sign. I came to this with the assumption that we want as many, what I share with Chairman Risk, that we want as many people on the ballot, as she spoke yesterday, as we can get on the ballot, unless we can't, unless there's a good reason not to. That's the assumption I came to this task, brought to this task. But I also would very much like to thank the challengers, certainly Ms. Rogers in particular, but also Ms. Risk, because they call you to account. They call you to account. There are things that need to be done, and you need to do them. And this is true in every part of life, and it's true here. As both Tony and Mr. Lorenz have noted, there's a great laxity, probably not only here, but, you know, those of you who know me, I'm a forms guy. I made my living as a writer. I'm a wonk. I love this stuff. Not all of it, but we need to take this very seriously. I'd also like to thank the candidates for appearing, also for filing. Some of them may be disappointed with what happens here, but there are remedies available, either through the courts or in some cases, others. And so, you know, these are judgments of law, not judgments of person. The third thing, I'd like very much to thank my colleagues on this board. Tony, of course, represents the Republican Party, and I'm the Democratic representative, and we have a long history as former chairs, longtime former chairs of our party. It's not that we've never disagreed, but we've always gotten along. And I haven't seen any hint of partisanship from anyone in this, in our discussions so far, and I don't expect to. So I'm grateful, because when you take an oath, if you're a poll worker or an election board worker, you quit being a Democrat or a Republican. You become a citizen representing the interests of the citizen. And I take that seriously, and I think my colleagues do too, and I very much appreciate it. Also, I'd like to thank Mr. Lorenz, whose context and guidance, because these are issues of law, and I'm not a lawyer, and neither is Tony, have been invaluable in helping us organize our thoughts, which we'll find out, but most of them seem to be going in the same direction. A couple of other overriding assumptions, you know, we did spend a lot of time on CFA 2 question 713, and we did that over and over and over again, and so we won't have to do it every case here. I will just say at the outset that I concur with Mr. Lorenz's notion that that the signature covers, as far as I'm concerned, and you'll see that in my remarks. The second remark about that is that, you know, many of the challenges were technical challenges. Error is not fraud. Error is error. Sometimes it can be fixed, but the assumption that if you made a mistake on the form, therefore your form is entirely invalid, I don't share in many cases. There's sometimes you can't avoid it, but I don't share the assumption, you know, error is not on its face fraud. So that also said, we did spend time on both delinquent and defective CFAs, and I can tell you that as a member of this board, I will press for more hearings on these, and I assume that Tony will join me in that, on these CFA forms, because folks, we have to take this seriously. We have to do this right, and we haven't been. I think there are improvements that can be made in the clerk's office also, although I don't agree that, you know, I also wanted to thank Diane and her staff for how hard they work, because they do work hard. But I don't agree that the absence of a signature on one page, if it's stamped on one page and signature on the other, is clearly received in the clerk's office. And as Henry Fielding, the writer, said, it's a distinction without a difference as far as I'm concerned. So that said, I'm grateful to many people, but I do want to advise that there will probably be more coming on the audits. We need to take that seriously. The public needs to know, has the right to know. And this board, I think we'll act. So, Mr. Chairman?
Thank you. Okay, so we're going to go into the individual cases, and I've chosen to start with Dustin White. Mr. White was challenged on several points, but the overriding factor, in my view, and this will, I will give both of you an opportunity to share your view as well. The overriding factor, in my view, is that he did not submit a CAN 12 with the CAN 2, okay? So CAN 12 is your financial disclosure. There are, among those 9 things that Mr. Lorenz noted, one of them is very adamant in the law. It says the clerk shall not accept an application, a CAN 2 application for candidacy, without the CAN 12. And the CAN 12 was not included by Mr. White. It is not a form that can be edited, it is not, or amended, and it is not one that can be added after the fact. For that reason, in my estimation, on Mr. White, that disqualifies him from the primary ballot. Now, he does have recourse. It was clearly an error on his part. I don't believe it was malicious in any attempt to hide anything. He just didn't follow the law, but the law is very clear on that one. We don't have wiggle room. Out of those 9 things, those are musts. They are not things that the board has a choice to make a decision on. And because of that, it overrides all the other challenges. So in my view, it makes all of those other challenges moot. He can talk to his party, and they have the right, because that is an open ballot. If we make this determination today, that will be an open ballot position. The party chair then can hold a caucus, and they have until July 3rd to do so, and put him back on the ballot for the general election as a Republican if they choose. Or he can run as an independent, either one. So it's not killing his opportunity. He is qualified in all other respects. But in my estimation, our hands are tied on this particular one, and we have to make the call that we have, because it's spelled out in the law, cannot accept. So with that, I'll open it up to both of you.
I think this is one we don't have a choice on. I regret it, because I don't think that he intended to defraud or hide anything. I just think he didn't do it. And the deal is, you have to do it. You have to do it. And he needs to be responsible for being aware of that, and I hope he will be going forward. As Tony said, I don't, with regret, there's no wiggle room on this. This is the law, so I would concur on that. He does, as Tony pointed out, he has remedy, but I hope it serves, not just in his case, but it serves as the warning I was talking about earlier. You need to take this stuff seriously. You can't just walk in and say hooty-dooty. So anyway, I concur. We have several check marks on our form, but the next to the last one, that the candidate did not file CAN 10, is the one that's relevant.
CAN 12, yes.
12, sorry. Do we need a motion to do that?
Well, I was going to
we
let
should hear from Diane.
Diane comment.
Before you make your motion, one other thing I wanted to point out. This is one of the cases in which there was some evidence that the candidate indicate that they did not file all the financial reports that might be required. You may be wise to look at those particular findings to indicate that a notice of opportunity will be given to respond to that, even with this qualification, because these financial reports have a life beyond the candidacy.
Yes, as we go forward, yes. Okay. Yes, sir.
And I agree. Dusty did not present a CAN 12 by the deadline, so the clerk's office will have to reject it.
So that being said, I'll make a motion to deny or to uphold the challenge and disqualify Mr. White for the primary ballot based on the fact that he did not fill out and submit a CAN 12 along with his CAN 2 application.
Second.
All in favor?
Aye.
Aye. And I will add what Mr. Lorenz said, that we will make Mr. White aware that the CFA forms can still be brought up in a separate hearing, and we may need, he may need to take some remedy there as well, or curing, or whatever we want to call it. So according to the vote on this board, we have found Mr. White disqualified and ineligible to appear on the primary ballot. I will go ahead and pass mine around for official signature.
Diane?
My last name is typed wrong. It's an S instead of a Z, but I'm signing it with my S.
Okay.
So just so
Sounds
that-
like a challenge to
just
me.
so that everybody knows that it's just misspelled. It's okay.
I do want to say again beforehand, and I agree with Mr. Coffin, that I appreciate all the candidates. But we've tried our best, at least I have, I'm sure they have too, to just follow the law, allow grace where I can allow grace, and where I don't have a choice, I'm just going to have to make that call. The next one I want to address, these are what I consider the open and shut cases. The next one will be Mr. Walter Newman. And Mr. Newman testified before this committee that his intent, he really didn't, his intent was to run as an independent. He didn't want to make a selection on either one of those. He has that absolute right to run as an independent. However, in the state of Indiana, independents don't run in the primary, so independents will be on the general ballot. The challenge was brought by the GOP chairman because he checked the Republican Party, and he felt like that's what he had to make that decision, but that was not his original intent. So the challenge will be upheld, in my opinion, by Ms. Risk, that he did not vote in the last two primaries. And again, that is one of those reasons that are cut and dry in the law. So that's not an area that we have wiggle room on. If he had gone to the chairman before and they signed off on him, well, before the law changed, now it's two primaries, and it's very adamant about that. So my personal finding will be that that Christy Riss's challenge is upheld, and Mr. Newman will not be eligible to run on the GOP primary ballot for this spring. Frank?
Yes, but Mr. Newman, I want to make clear that you should be on the ballot in the fall if you want to be. You're not limited by the same deadlines that either GOP or Democratic primaries are. You could and you shall, if you choose to continue, be on that ballot. And I urge you to consult with the clerk or anyone else you want about the appropriate way to do that. You can be on that ballot. You don't have to be a Democrat or Republican, and I regret the confusion. But this is, as Tony says, this is not one where we have a choice. We can't put you on the ballot as a Republican. We just can't do it. It's against the law. So it's nothing against your candidacy in any way, but this is not one where we have a choice. So
Agreed.
I agree that the challenge must be upheld, and that you won't appear on the ballot.
I agree.
So in that, I'll make a motion that Mr. Walter Newman be disqualified and eligible to appear on the GOP primary ballot.
Second.
All in favor?
All right.
Aye. And again, I will pass mine around for signatures. Get my fingers working. And the next one that I would like to go to is Mr. William Falk. And Mr. William Falk also was challenged by Christy Risk, the GOP chair, for the same reason that he did not vote in the last, the last two Republican primaries, and therefore is not qualified to be on the GOP ballot. For the same reason that we just mentioned with Mr. Newman, it's just a state law that they have to, and it's designed by both parties, that they have to vote in the last two primaries. Because of that, Mr. Falk did not appear before us for testimony, but because of that, we need to come to the same conclusion, in my estimation, that Mr. Falk is not qualified for the GOP primary ballot. However, he has the same remedy that Mr. Newman does. If he would like to run as an independent, he has absolute right and is encouraged to do so. With that, I'll turn it over to...
I concur. This is a no choice error, and the voting records or absence thereof were presented, and I move that Mr. Falk be disqualified and ineligible to appear on the May primary ballot.
I will second that. All in favor?
Aye.
Okay. The next one in line will be Miss Sandra Calvert.
Hold on a second. Thank you. Gotcha.
And my finding on this particular one was the challenge is that the only challenge that had any merit was that she did not fill in her name in the middle section of Can 2 that you need to fill out how you want your name to appear on the ballot. The original challenge said that she did not sign under oath, but that was proven not to be true. So the only challenge that had any merit was that she did not put her name in the middle, in those middle blocks stating how she wanted it. However, my review of that and conferring with our counsel, I came to this conclusion that the candidate's failure to fill in the name as it would appear on the ballot is a harmless error, and her sworn testimony that she would have filled in those blanks to conform to the name, middle initial, and surname, first name, middle initial, and surname, announced in her Can 2 filing constitutes the information to be used on the ballot. In my estimation, I will select that, and I will deny the challenge from the challenger and allow Mrs. Calvert to stay on the primary ballot.
I agree with the notion that is a completely harmless error, and if you look at that form, that doesn't look like a signature block. In all the forms we've seen, that's the one that least looks like a signature block. Anybody can miss it. I've missed it myself in former times. It is a harmless error. And as for the, we're going to have this discussion a lot, but some of the other things regarding question 713 and all that business, Mr. Loren's remarks cover my attitude. They also challenged that the signature did not, the clerk's signature did not appear at appropriate locations on the 12, but the file stamps, the seal, and the evidence of her intent to file and the clerk's intention to accept those documents is conclusive. And as far as I'm concerned, I see no reason that she should be disqualified. This is probably the least harmful error that we've confronted in any time. So I would move that she be qualified and eligible to appear on the Democratic ballot in May.
Okay.
Let me direct your attention to the specific findings. it would be good to go through these in this case just to make sure we have everything. The first box for the candidate who did not sign can it would be incorrect because it does appear that her name appears and the signature of the clerk is there, okay? So the second box would be correct that she did sign. Then the candidate did not fill out the name information, and the fact that that failure is a harmless error are covered in the next two. The last one is that the clerk's signature does not appear on the appropriate location of the can 12, okay? That may also be something you want to make findings about, and also the fact that the signature, although it does not appear by the clerk at the appropriate location, the file stamps, the seal, and the evidence of intent substantiates the clerk's ministerial act was harmless error. In this instance, the substance of the transactional history of the presentation and the intent of the form, that the intent of the form overcomes the form itself, the form of the form. You may want to decide that those are factual matters you need to address.
Yes, and thank you. I was going to mention that after these two spoke because I caught my error in that, and I totally agree with that. Because those were issues of challenge, they do need to be addressed, I believe, with our check marks and then our signatures. So in my finding, I agree with Mr. Lorenz. The candidate did sign the form, Can 2 under oath. The candidate's failure to fill in the name as it would appear on the ballot is a harmless error, and her sworn testimony that she would have filled in these blanks to conform to the name, middle initial, and surname announced in the Can 2 filing constitutes the information to be used on the ballot. And the last box, that the clerk's signature does not appear at the appropriate location on the Can 2. However, the file stamp, seal, and evidence of intent substantiates that the clerk's ministerial act was harmless in error. In this instance, the substance of the transactional history of the presentation and intent of the form overcomes the form. Having said all that, I will make a motion to deny the challenge on those three bases and allow Mrs. Calvert to stay on the Democratic ballot for the primary.
Second, yeah, I had checked those boxes on our preparation material, but I didn't go read through them all, but perhaps we should address those more specifically as we go forward. We were here a long time yesterday and last night, so, all right, so I second your motion.
Okay. All in favor? Aye. Do a vote. I didn't hear your vote. Was
Yes.
aye, okay.
I'm sorry. Change your battery, man. Yeah.
Okay.
Damn.
Okay, then, okay, the next one I would like to go to is Mr. Sam Hobbs. Mr. Hobbs was challenged on several, let me get to my other paper here. If I can find it. I must have put a couple together here somehow. There it is. Okay. According to the Can 1 filed by the challenger, Mr. Hobbs was challenged according to the challenger, that he did not complete the Can 2 as law provides. See attached paragraphs 1, 4, 6, 7, 7A, 9, and 11. Interestingly, she did bring up challenges on the CFA forms in her testimony, but it is not on the Can 1, which is the official challenge document. My particular finding was that Mr. Hobbs did sign the Can 2 form under oath. So that challenge I thought was inaccurate. She did have questions as to she challenged that his signature on line 12 in that box again of candidate certification was checked yes, and then she challenged that because she said that he did not file all of his CFA forms accurately. She also made an accusation or a challenge that at least one of those forms, I think, was delinquent or not filed at all. My personal finding on that was that it looked to me that like all of those forms had been filed, although incorrectly, or at least attempted to be filed, but they were incorrect. I think Mr. Hobbs acknowledged in testimony that there were errors on the forms, and they were working on trying to get those corrected. What I relied on this particular one was I went back again to the difference between what the law says regarding delinquent and deficient or defective. It looked to me, from my understanding, that these would be fit under the defective category, and that I would like to give Mr. Hobbs time to give those corrected. If those forms are not corrected in that period of time, then I feel that we would have to defer that to a separate hearing and discuss penalties, civil penalties.
Filed these yesterday.
Okay, and then the clerk has let me know that these were filed yesterday, and as far as Mr. Hobbs and his wife, who is the treasurer, I believe. No, in this case, Mr. Hobbs is treasurer. At any rate, we can review those forms again and determine whether we need to take that to another hearing and discuss potential fines for, for tardiness or incorrect forms that were filed. But with regards to the challenge here of whether or not he's qualified to be on the ballot, my estimation is that he is qualified to be on the ballot and should not be removed from the ballot, especially for CFA forms. Those forms, according to everything I'm reading in the law, they have separate civil penalties and separate, I think Mr. Lorenz even said that the state legislature seemed to have what's the word I'm looking for? Their intent was to treat those separately than the Can 2 and the Can 12 documents. And so there's separate things that have to be considered on those, but those on them on their face or by themselves do not disqualify a person to be on the ballot. Okay. I know that was a confusing mouthful, but my finding would be that he did sign the form under oath, that he did not fill out all of his campaign finance forms accurately, and because of that confusion, there may have even been some late ones. I don't know. I couldn't determine that, but it looked to me that they fit more in the defective category than they did in the delinquent category. I'll open that up to you guys for discussion too. Frank,
Well, this is an object lesson in what we were talking about earlier, about making sure we get things right. There are lots of errors here but I don't believe that they rise to the level of disqualification. As Mr. Lorenz points out, the financial reporting goes on beyond the life of any given campaign. And so, you know, I can assure you, or at least, I don't know, we'll see what the other people think, but this and several other cases, I am going to press for those audits. I want this county to be known as one that does things right, and it makes more work for this board. I'm sorry, but we will be making a commitment, I think, to look at those. But I do not believe that this rises to the level of disqualification, but I think we'll take steps to make sure every candidate takes this stuff seriously. We need to do this right, and first time out.
Okay.
So I concur.
So as to the findings, you'll see the second line is that the candidate did sign Form Can 2 under oath.
Yes.
That the fourth item is that the candidate did not answer question 12 accurately.
Yes.
However, the failure to answer the question accurately does not serve as a single independent standalone cause for disqualification. And then further down, that the candidate did not file accurate financial reports as required. However, the finding does not provide a standalone basis. That's duplicated. But then further, that the board finds that the campaign financial reports are in controversy and that the notice and opportunity to respond must be given to the candidate for a separate hearing, at which time the board will audit all designated past or unfiled campaign finance reports and reporting requirements and will issue such fines, penalties, or referrals as may be determined at that hearing. So those would be the ones I think you are.
That's the ones I checked, yeah. So,
And that
Yeah,
is
and I think that's what
accurate
Tony
for me
has.
as well. How about for you, Diane?
I agree. I think he should stay on the ballot.
Okay. All right, with that being said, I will make a motion to deny the challenge that Mr. Hobbs should be removed from the ballot, and having specified those 4 areas, we will do a continuing audit on those CFA forms, and we may indeed have to have an additional hearing and go through that information, and you will be notified of all of that process. Okay? And that's all in my motion?
second.
Okay, all in favor?
Aye.
Aye. Okay. Mr. Hobbs will stay on the ballot.
Thanks, Hank.
Make sure I'm putting the right piles of all of these in the right places here. All right. I would like to go to Amy Meyer next. According to the Can 1 challenge on Amy Meyer, she did not complete Can 2 as the law provides. The attachment for paragraphs 1, 2, 4, 6, 7, 9, and 11, and they were also challenging, she was also challenging her residency. So I want to say a couple things about this. I have determined on the first point that she did sign under oath her Can 2 ballot, or application, and that is stamped in the appropriate place with Diane Stutman's signature and Linda's initials afterwards. So on that first point, I find that the candidate did sign the Can 2 under oath. On the second point, which was, I believe, the questions regarding 7 through 13, of not being initialed correctly. Let me look and make sure I'm not stating that inaccurately. Yes. Again, Ms. Rogers challenged that she signed item number 12 in that box and that she did not file all of her campaign financial forms correctly, and therefore Mrs. Rogers' contention was that the form is invalidated. And I think we've already established well up to this point that a missed signature in those boxes or a signature saying, yes, I filed all forms correctly in the absence of intent to deceive or defraud does not rise to the challenge of disqualifying somebody from the ballot for that reason. So with regards to that point, I'm going to, on my form, I'm going to check the candidate did answer questions 7 through 13 of Can 2. With regard to the financial reports, this is an interesting point, but the Can 1, even though there were significant errors, primarily in the Can 12, many blocks were left unanswered altogether. Most of those would have been NA. They should have been filled out, there's no question. But the form was filled out with her name and it was signed, and it has to accompany the Can 2. Again, I think those are significant errors that need to be addressed, but they are not listed on the Can 1 from the challenger. Even though she talked about them in her testimony, they are not on the list for that. So in my estimation, we cannot have a finding on her Can 12 document under this challenge. So I'm not even going to address that particular issue other than what I've already said. With regards to residency, I do not feel like the challenger met the burden of proof. That proof is on the challenger, that she does not live on her Goose Creek property when clearly she does. So I don't know why there's a discrepancy between building permits in the building department and the structures that are actually out on that property. I don't know if it's an address error. Sometimes that happens. I would encourage the Myers to get that corrected in whatever departments they need to get corrected. But to say that she doesn't live there when they live there is not an accurate challenge in my view. Frank?
Yes, I think the state of the Can 12 was a disgrace, to be blunt about that. There's 15 questions there, and the second one is who's your husband or who's your spouse, and she just didn't bother, and I was troubled by that. But at the same time, that my being troubled by that is irrelevant because the challenger didn't bring it up. I mean, she brought it up in testimony, but not on her formal challenge. So my being troubled by that kind of doesn't matter. I think it's the only thing Ms. Rogers missed, failed to challenge.
Yes,
But the rest of it, I have a slight difference in my box. She did not answer question 713. However, the failure to do that does not serve as a single independent clause for disqualification, just as we've seen before.
Yes.
So my difference there is slight, but it comes to the same thing. Also, I believe we've had this discussion about the financial forms. We're probably going to have to talk to her again. Even if they're minimal, they still have to be done. She spoke of having a campaign 11 years ago, I believe she testified, but
Yes.
she didn't mention that she was, I didn't even know she was the encumbered surveyor, that she had one 4 years ago.
Right,
So
right.
that trail needs to be established, and we'll probably be talking to her again. But I believe that the
And I also could agree that she lives where she says she is. I don't see any reason to dispute that. So I concur that she should remain on the ballot.
Okay. This is the Can 2 that I based that on, and she does have initials in all of those. And her question was on the
right,
12. So there
right.
was a little bit of confusion on that, but
Yeah.
I selected that she did answer those. Albeit, as we've mentioned, there were significant issues with
I'm
the
okay
Can
with that.
12.
I'm okay with that.
Yeah, and I concur that she does need to, once we get to that stage for the next hearing on financial forms, we do need to include Ms. Myers in that.
she'd be on the
Because,
list.
Ms. Meyer, because that is, those were substantial errors that there really is no excuse for.
Neglect.
Yeah, it was neglectful. It really was. So having said that, I've checked, I'm sorry, Diane, go ahead.
I do see where she has, also on the Can 2, initialed and signed the 7 through the 13.
Okay.
I will say her paperwork was lacking. She did not answer some of the questions. She did not follow the instructions on those. And so, that being, I still believe that she should be on the ballot.
Stay on the ballot, okay. So just for unification here, I have the second box down checked that the candidate did sign the Can 2 under oath.
Yes.
And then I had that the candidate did answer questions 7 through 13 on the Can 2.
I'll amend mine to concur.
Okay.
I was focusing on the one questionable
Okay.
one, but I'll amend mine.
Thank you. That the candidate did not file all campaign financial reports as required. In her case, I believe it was not just defective, I believe there were delinquent forms as well. And so I think that is probably the appropriate box, that the candidate did not file all campaign financial reports as required. That would come out further in a hearing as to whether or not she did file them and they were just inaccurate. But it appears to me that not all of them were filed. Do you have a difference of opinion?
We don't. But we also have the next box that says that doesn't rise as a standalone
Correct.
cause, and so I have that one checked too.
Okay, gotcha. All right, so rather than just the blanket statement, the candidate did not file all campaign financial reports as required, you would prefer that we did, the candidate did not file accurate financial reports as required. However, this finding does not provide a standalone basis for disqualification.
That's what we did, and that's what we've done so far.
Okay.
In these hearings.
I'm good with that. Diane?
I agree.
Okay. And then the last portion, that the board finds that the campaign financial reports in controversy and that the notice and opportunity to respond must be given to the candidate for a separate hearing, at which time the board will audit all designated past or unfiled campaign finance reports and reporting requirements, and will issue such fines, penalties, or referrals as to be determined at that hearing. Now, this is interesting because her Can 12 was not challenged in the original challenge, but in our review of all of the process, it clearly is lacking, and so I would prefer to list that last box on our findings as well. Is that allowed, Richard?
We have the one concerning the address provided on Can 2 as the proper legal residence of the candidate,
Yes.
okay? And then there's one that there's a designation of Franklin as a precinct box in the line identifying, and as the elective office is harmless error.
Yes.
Okay, yes.
I have reformatted that and brought them back up to the same style as the others.
Okay, okay. And then, so on the information before, I'm checking that she will be notified that we will have additional hearings, and she will be included in that as well. Do you concur?
Absolutely.
Okay,
Yes.
okay.
But
And
I
then-
don't think we can bring up the Can 12 on this form,
We
because
can-
it was part of the challenge.
Right.
It was not part of the challenge.
Right.
So,
That is true. So I'm not sure, Mr. Lorenz, if if we check that box above those others?
There's no need to make findings on issues that are not part of the challenge.
Okay, okay.
And again, the board could make even more delimited findings, but I think it's appropriate in this particular case to give completeness to the findings that you're making so that all of the challenges can be heard on appeal if necessary.
Okay.
Okay?
So that being said, I'm going to leave my check on that box, but if it, I'm sorry, I'm going to strike my check on that box and initial it, but.
Which
but,
box?
This one right above those bolds down here that said the board finds that the campaign financial reports are in controversy, because she didn't bring that up in the challenge, so.
The witness did acknowledge, I believe, that there was some shortfall in her
did.
reporting.
She did.
You
did
have
testify to
that
that.
basis for deciding, as opposed to any other candidate who testified, if they indicated that there was inaccuracy, it would be appropriate, it would appear, for the
Okay.
board to proceed with that audit.
In our initial questioning of her, you asked, are your forms filed?
Yes,
Are all they
that's
in?
true,
And that's
that's
when
true.
she testified that, nope, they're not.
Okay,
So,
okay. Let's use yours form then, since I've already got a scribble out on
I'm
that.
taking all of your remarks and putting them into a final form here.
Oh, okay.
So that that can be the final document used, okay?
And then, so we will re-sign that one
Right.
afterwards. Okay, based on our motions, okay. So then motion with those boxes that we've just mentioned, and stipulating that the address provided on the CAN 2 is the proper legal residence of the candidate, that the designation of Franklin in the precinct box on the line identified the elective office is a harmless error, and that Ms. Meyer should be allowed to stay on the ballot, or is qualified and eligible to appear on the primary ballot. I'll make my motion with that information.
Second?
All in favor?
Aye.
Okay,
You don't mind?
yeah. Oh, let Frank sign it, sorry. Okay, next in my line is Ms. Lori Warner. And the challenges, according to the CAN 1, is that Ms. Warner did not complete CAN 2 as provided by law. See attachment, paragraphs 1, 2, 4, 6, 9. Required to file CFA 1, however, CFA 1 is invalidated according to the signature. Now, let's take the first point, that Ms. Warner did not sign the CAN 2 under oath. I think that was clearly stipulated that she did indeed sign that under oath. So I think the second box, in my view, is appropriate on our findings form. The next question down, or the next challenge down, get to the right page here. You got too many forms floating around here. Get to her. Somehow I've misplaced her CAN 2. There it is. Okay. With regards to the second challenge, that she did not fill out 7 through 13, she did not fill those out, but however, we have already established that by virtue of the fact that she signed inside the box, and then the form itself was verified and witnessed in the clerk's office with the appropriate seal. My finding is that the candidate did answer by default the candidate did not answer all questions 7 through 13 on Can 2. However, the failure to answer the questions does not serve as a single independent standalone cause for disqualification. That would be my selection. With regard to the CFA 1 challenge, this is interesting. I researched that. She did fill out her Can 12, by the way, appropriately, and it was signed and witnessed or affirmed in the clerk's office, so that was appropriate. With regards to the CFA 1, two things. One, that is a form that's allowed to be edited. She did not sign the form. So I looked up in our county election board guide, and this was just from the recent training, and interestingly it says, if a candidate does not file a CFA 1 form, the county election board is to file a form on their behalf and signing them up, even without a signature. So the fact that she mistakenly did not sign the CFA form, though she intended to, it was in her packet and submitted with the other forms, it was clearly an oversight, does not disqualify her. Under my estimation, the state would not allow the CEB board to create a CFA 1 form for a candidate with no signature if the signature was a make or break deal on that. And that form is allowed to be edited. So my view is on that challenge is that it does not rise to the, it does not cause a reason for her to be disqualified from the ballot. Let's see, what wording is that on here?
It's the last box.
Very last. Yes. That would be mine. Frank, how about you?
I feel the same way. We've established the principle on question 713 of Can 2, which has been our guiding principle on every case so far. The challenger will have the opportunity to appeal that to court if that interpretation is, wants to dispute that interpretation, but we've been advised by counsel about that, and I feel comfortable with that. Again, the forms need to be filled out properly, but as Tony notes, CFA 1 is amendable. You can fix those. Some of them, like if you don't do the Can 12, you're just out, and you can't do it. But this one you can, and she should be given that opportunity and should appear on the ballot. If you want to walk through the rest of the boxes, Tony, go ahead.
Okay.
Why don't we start from the top then? So the
Okay.
second box down is that the candidate did sign the Can 2 under oath.
Yes.
Yes.
The fourth box is the candidate did not answer all questions 7 through 13, but they don't serve as a standalone cause for disqualification.
That's what I have.
And then we have for certain that the candidate submitted CFA 1 without signatures of the candidate, chairperson, and treasurer. And despite the missing signatures, CFA 1 is able to be amended and must be amended in accordance with applicable law. And this error is not a sufficient justification for denial of eligibility. Is there a campaign financial report issue on this case?
On the Can 1, the only thing on the official challenge was that the CFA 1 was not signed or was invalid.
Okay.
For question number 10.
So those findings are not required in this.
Correct, right. So I have the second box down, the fourth box down, and I think I'm missing one, and then the very last box, despite the missing signatures.
Right.
Am I missing one?
That's what I have.
Okay, very good. So I will make a motion to deny the challenge and allow Lori Warner to stay on the primary ballot.
Second.
All in favor? Aye?
Aye, I'm sorry. I was thinking ahead.
Oh, I'm sorry, I didn't give you permission before I made the motion. Opportunity to speak, so please speak.
I have concerns that there's 4 signature places and none of them were signed,
On the, which one?
the CFA 1.
Okay. But the CFA one can be amended.
It can be amended.
Okay.
However, we just don't have anything on that original one, not one signature, and that is concerning to me, that could be an issue.
Okay.
You know, they can amend the form, but to me, the signatures take it to another level, that there are 4 of them that are missing.
Okay. So the one point that I would make in that is when I did look up the rules regarding that, is that the CE board could fill out a CFA one for them on their behalf with no signatures.
Right, if someone doesn't turn one in,
Right.
one can be done.
Yeah. So,
So your point
Is,
is that
She did turn it
without
in.
having signed it, as far as you're concerned, she didn't turn it in. Is that right?
that's,
that fair?
that is how I feel.
All right.
That-
But Tony's point is that since she can amend it, or we can file it
without a signature,
without a signature,
that it wouldn't rise to the challenge of disqualifying her. It's not that it wasn't incorrect. It clearly was incorrect. Any other comment on it?
Nope.
Okay. I have a motion on the floor and a second. If there's no more comment, I'll go ahead and take the vote on that. All in favor of qualifying or denying the challenge and leaving Lori Warner on the ballot, say aye.
Aye.
Aye. Opposed?
Aye.
Okay.
I'm sorry, was that an opposition?
Yes.
The clerk?
Yes. So the motion still carries 2-1, but it was Tony Volker and Frank Coffin for, or deny the challenge, and Diane Stutzman to uphold the challenge. Okay. Oh, sorry.
So do I just not sign this one?
Yeah, in that case, since Diane was a no, would she just not sign that one?
You can you'll file the response signed with the items, including the fact that the missing signatures can be amended and must be amended before Apple law. And I'm recording the fact that there was a nay vote by the clerk.
Okay,
All right.
so I would say it's still signed because he's got the information recorded. Okay, the next one in my stack.
Mr. Chairman,
Yes.
could we take a brief break? So I
Yes,
can get my
absolutely.
nose under control?
Let's take a 10-minute recess, and we will reconvene at 25 after.
Thank you.
Thank you. Next one on my list is Norman Warner.
Mike's.
Oh, sorry. Thank you. Great. I'll re-say that. We're calling the meeting back to order because we didn't have the mics on. Next one in my list is Norman Warner. And just going through the challenge real quick. Well, I can get my fingers working. Normally I have her can one right on the top. I must have went past it already. Okay, according to the challenger's Can 1 form, says that he did not complete Can 2 as law provides. He attached paragraphs 1, 2, 4, 6, and 9. So we'll address each one of those. One is that he did not sign under oath, and I think we have already established clearly that that the form was filed with the clerk's stamp. It was just filed in the, or stamped in the wrong location, but we had made a previous determination that that was still correct. So box 2 on our form says that the candidate did sign Form Can 2 under oath because the board has determined and interpreted that the Can 2 is file marked with the clerk's signature, sealed and submitted at the same time and the transaction, or as the transaction of the Can 12, which bears signature of the clerk and attestation. The clerk's ministerial error is not the fault of the candidate, and the intent and submission of the document, was under the color of the affirmations contemporaneous given. So that would be my finding on the first one. As to the second point, she makes the point again that the candidate, that the document was not filled out completely, and part of that was because of the boxes 7 through 13 were not checked, except for actually 12 was, that he filed his previous forms. The board has already established that Mr. Norman's signature inside that box constitutes his agreement to those individual items under this circumstance and does not rise to the challenge of removing him from the ballot under that situation. That would be the fourth box down. I believe the candidate did not answer questions 7 through 13 of Can 2. However, the failure to answer the question does not serve as a single independent standalone cause for disqualification. There was no evidence of fraud, deceit, or malfeasance substantiated, and the candidate acknowledged his misunderstanding and misreading of the document. Her next point was item 4. No, let me pass that, I'm sorry. Her item 4 was simply that she has the right to challenge, which she did.
Yeah.
Item 6 we just established, and then item 9. That Can 2 cannot be amended. I could not find anything in the law that states that the Can 2 could not be amended. However, regardless of whether the Can 2 could not be amended, we had already found that the signatures were intended, and the signature inside the box was sufficient for the reasons that we just said. Now, interestingly, the candidate did have, as we've determined, several errors on their CFA forms, and they were working to correct those. However, that is not brought up on the Can 1 challenge, and therefore cannot be considered on our.
Well, she
Statement here.
mentioned the problem of the treasurer serving for 2 separate campaigns.
Right, she mentioned that in her testimony.
That's a CFA, she mentioned that, and that's a CFA 1 error, and we did talk about it.
Right, she brought it up in her testimony, but she did not put that on the original challenge
Item
form on
10.
the Can 1.
Item 10 on her Can 1.
I don't have, on her Can 1 for.
Oh.
Yeah, there is no, Norman Warner, she did not put item 10 on her Can 1.
Well, then we spent a lot of time talking about it, didn't we?
And I believe we have established that,
I agree.
that he fits into the same category as the CFA forms that we talked about earlier, that needs to be further reviewed and
So-
probably brought up in that testimony or in the other hearings because those forms were not correct. And, but again, it's not on the Can 1.
Nonetheless, the testimony given by the witness evidenced the fact that there are financial omissions. And you may want to decide that you make a finding that the candidate did not file accurate financial reports as required, which covers a multitude of sins. However, that finding does not provide a standalone base for disqualification, and you may want to also incorporate the need for a further campaign financial report hearing.
Okay?
That's boxes 1, 2, 3, 4 in the last one. Because it was brought up in testimony.
You're right.
Even if
And
she
I-
didn't note it on the form, she spent a lot of time talking about it.
And he
And he
addressed
did
it
too.
in testimony,
And
yes. sir.
both in terms of the current forms, but also past financial reports.
Right, yes,
So-
you're correct, and I had forgotten about that. Since the candidate himself brought it up in testimony, then that is a valid reason for us to include it on the list.
I think that's so because when you're having these hearings, you're listening to all of the issues that can be raised before the Campaign Election Commission also. It's appropriate to take it up and all.
That's why you have it
Okay.
here. Yeah.
So on that particular one, I have box 2, box 4, box 5, and the last box 7 checked.
That's what I have.
Try 2, 3, which is true, 4, 5, and 7, okay?
Okay, now, on,
The candidate did not answer 7 through 13.
right, but the one right below that says that the candidate did not answer questions 7 through
And,
13.
yeah, you could use that standalone, that's fine, yeah.
Okay,
Yeah, I
Got
thought
it.
it was that.
okay,
Yeah, it's
good
good.
deal. In that case, I will make a motion that the original challenge is denied and that Mr. Warner will stay on the ballot. However, we will talk to him further about the errors on those CFA forms, and he will be asked to attend those hearings as well. It's a
Second.
long motion.
Second.
Diane, do you have any input on that?
No, I agree.
Okay. All in favor?
Aye.
Any opposed? Motion carries. Mr. Warner will stay on the ballot. All right, and in all my pile, I have one more. That was Mr. Pasenica. I just need to find his in my stack of stuff. Here it is. Okay, the next one, the last one, is Nicholas Pasenica.
Whose name we finally pronounced right.
Yes,
Yeah.
yes. I listened closely when he said.
I wrote it down with little marks.
Yeah. So the Can 1 challenge on that from Ms. Rogers is, she challenged initially that 11175 Private Road 900 West, Poland, Indiana, is reported as residency information. This address has no assessment for any residency. She was basing that on the, assessor's office residency cards. However, I believe that Mr. Pasenica did produce utility bills and sufficient proof that he does reside at that address, and in my estimation, that the challenger did not overcome the burden of proof to prove that he was not qualified to run as a resident.
I felt the same way. Directly in testimony, both Mr. Lorenz and I copied his wording, said to the challenger, can you refute Mr. Paseneca's claim that he lives there? Can you refute that? And she could not. She went back to her cards and her documentary evidence, but also, there was he supplied documentary evidence, including one from a court, and if the federal court thinks he's lives there, then I'm content to say he lives there too. So I concur.
Okay. The only thing that I saw on that CAN 1 was this with regards to the residency. We determined or specified that there may have been an LLC missing from his CAN 12, but that was never substantiated, and so I don't know that.
Nor was the claim that some of his answers on the two were
Incorrect.
or false.
Right.
There was no evidence provided to that.
Okay, so the box that says that the candidate does meet the residency requirement under IC 381 and the Indiana Constitution, the candidate provided substantiating evidence that he has lived at the stated address in the CAN 2 for a period in excess of 8 years, that he pays utilities on the property, that he receives mail at that address and utility billings, that he lives on the property in a structure that serves as his physical residence, that his driver's license conforms to this address, and that he has recently filed bankruptcy in the United States District Court for the Southern District of Indiana, Terre Haute, Indiana, using this address as a jurisdictional authority. Challenger's contentions and allegations do not meet the burden of proof and are insufficient to refute the testimony of the candidate. That is the appropriate box in my view.
Is there a challenge on the CAN 2? Because we have a box
Well-
up there. The candidate did sign CAN 2 under oath. We're satisfied with that. And that the candidate did answer question 713, and the challenger's contention that the answer is untruthful, which was brought up in testimony,
Yes.
is unsubstantiated. So I think those boxes should be
Yes.
checked too.
So number 2 and then number 3, that the challenger's contention that answers are untruthful is unsubstantiated.
Box 4.
I'm sorry, 2 and 4.
Yes, sir.
Yes, okay. So that would be 2, 4, and 6, is that right? Mm-hmm. Yes. Okay. Based on the evidence presented and the testimony of Mr. Paseneca, I would find that or I'll make a motion that he is qualified to stay on the ballot under those circumstances.
Second?
Diane?
Should I vote on this one, or
Question again?
should I vote on this one, or?
Mr. Paseneca is filing for the
You may
clerk.
wish to abstain because he's running for the same office as you are.
Okay. Do you have any comments before we actually take the vote?
No.
No? Okay. So the motion is on the floor and it's seconded. All in favor? Aye. And do you want to just publicly say you abstain?
I abstain.
And the reason for your abstention?
We are
Opponents?
opponents
Okay.
in the primary.
Fantastic. Thank you so much. Motion carries. And Mr. Paseneca will stay on the ballot. Okay. I think I'm going to make a closing statement here. We've gone through all of these, and then I think Mr. Lorenz has a statement he would like to make as well.
Yes, please.
And then either one of the other board members are free to do so in addition. I just want to reemphasize, I want to thank everybody for this process. I want to reemphasize that it was long and tedious, but it was really, in the long run, it was a good thing. It was a teachable moment for us, and we all, we really needed to right the ship in this. We're going to be making recommendations as board members, both for our voter registration office, and I will make some recommendations on additional items to hand out to the candidates when they come in to get an application, to re-emphasize these things. And I'm also, from my point, I'm also going to talk to our county chairman and encourage that we get some more training, do more training in our local party as well. I don't know how Mr. Coffin feels about that on his part, but this is a serious matter, and we want everybody to understand that that we take it seriously and that we do need to do these forms correctly. There will be ongoing hearings for the CFA forms, and there may well be some penalties assessed in those hearings based on the information that we study and facts that we come to, or conclusions that we come to. Having said that, I will let Mr. Coffin make his closing statement.
My remarks would be very similar. I am genuinely, although our main challenger may be disappointed in some of the outcomes here, she does have remedy if she chooses to pursue it. But I am genuinely grateful to her for for raising these issues, and also for calling us to account, all of us, candidates, board members, all of it, clerks. I think there will be forthcoming action on some of these other issues because we have to get it right. I hope that we can begin that process this way. Again, I want to express my thanks also to the candidates, to my colleagues here, and to Mr. Lorenz. I think we've done as well as we could. This is a unique, I think, not only to this county, I believe this is pretty unique around the state to have this level of scrutiny. But I think we've done well, and I thank you for your efforts and attendance.
Diane?
And I agree, we just really need to, the candidates really need to educate themselves on what they need to do. There are booklets out there that we all have available to us to read. There are questions, we can't tell you answers to your questions. We need to work on our end to make sure that we take time and go over everything with everyone to make sure, let them know, take another look at this, and try to work together so we don't have these kind of challenges in the future.
I agree, and I agree with your statement. We are not allowed to tell people what to put on those, but we can very adamantly say every single thing needs to be answered. Do not leave any blanks on the forms. Answer everything. I can't tell you how to answer it, but you need to answer them, and then make sure that your signatures are affixed. And then, of course, from the clerk's perspective, that our signatures are in the correct place, from the clerk's office. So having said that, I'll let Mr.
One more thing, following up on something you said, Tony, I will be reporting these hearings to our party, including an emphasis to our chairman about what needs to be done about this kind of thing. Same thing,
Very good.
Dot your i's, cross your t's, get it done.
That's right, that's right. Mr. Lorenz?
Well, as we've said, there is a lot to be done even yet. The words due diligence come to mind here on the part of all the parties that are involved. Certainly the challengers have raised legitimate questions. They are properly formed, etc. The question has been, what is the consequence of any deficiency that was noted? And I think the board has addressed those issues today. It doesn't do us any good to further continue arguing about that. In fact, I would love to see a situation in which we no longer have to have these arguments and instead have a proper process to ensure we have accurate reporting from all parties throughout the entire process at all. I would hope that people who are challengers might sometime volunteer to candidates who are going to be coming in the next elections at all to review their forms. It doesn't necessarily take an attorney, but a person who's experienced and technically able can certainly call their attention to the most cursory parts of the forms and all. I have recommendations that I have made to the board and to the clerk and all, which I think will alleviate these things in the past, and I can't do anything about what has already happened. It is what it is. And the board has now made its decisions on this matter. I have followed along as the board has made its votes and decisions on this matter, and I have memorialized all those into a single form here for the appropriate signatures, including all abstentions and nay votes and all. I would like you to read that over and certify that that is correct, and I will then print this out. But if you would take take a 10-minute break now and review this document that I have prepared here, that I'm sure contains all the proper information, and certify that that electronic copy is correct, we can then close the meeting and you can sign the form officially as a further matter. This document would then be file marked with the clerk and be part of the record for all proceedings going forward.
Fantastic.
Sounds fine.
So before I do that recess, I just wanted to, I'd be remiss if I did not mention my appreciation for Mr. Lorenz and the board members, especially for Diane. This is so stressful when you're a candidate and you have to deal with all of these on top of it. It's very stressful, and I appreciate her due diligence on that, and of course Frank's, and I know that I spent the appropriate amount of time on it as well. But I just wanted to thank you all. With that, let's take a 15-minute recess.
10.
Okay, 10-minute recess. Then we will get the documents printed out. We'll reconvene, sign the documents, and then we will close out the meeting.
Turn off the microphones.
Hey, turn on our mics here. We're going to reconvene our meeting. We have our finding of fact and conclusions of law with the votes that we just took completed, and then noted by our attorney, Richard Lorenz, and he has printed all of those documents for our official signature. So I don't know, since we already motioned all of these, I don't know that we need to motion
No,
to sign these.
And we have-
Just memorialize it by the written document.
And
Okay.
we have verified in our recess that the document Mr. Lorenz produced conforms to the votes that we took on the sheets that we were working with.
Very good.
So,
Okay, having said that, I'm going to go ahead and start signing. The first one here is for Dusty White.
Oh, okay. Okay, yeah, we gotta get Diane to go.
Second one is for Sam Hobbs. Third one is Sandra Calvert. Oh, you know what? I'm missing some, because that's printed on both sides. I'm sorry. Let me have those- Let me have those back. That's okay. So Dusty White, that one's completed. Amy Meyer was the one I missed.
are you okay with them being printed on both sides?
It's printed both sides. You want it single?
It doesn't make a difference.
Okay.
Okay.
Each
Just not
side,
forget anybody.
yeah, each side is complete for that individual, so it should be fine. So this one is, you've already signed on Sam Hobbs. The one that you haven't signed yet is Amy Meyer.
Okay.
Okay.
And I have,
And then you have Sandra's on
Sandra.
one side.
and Lori Warner's on the other. I'll
Okay.
sign both of those and hand it
Yes,
back to you.
okay. Okay. And make sure I sign the other side too, would you please? I think I did. This one will be Norman Warner on one side and William Falk on the other. And this one is Nicholas Pacinica on one side and Walter Newman on the other. I think that one you abstained on. Yes, there we go. Any final comments by our board or attorney?
Just mechanical, the document that's now been signed by the board constitutes the final order in this matter type thing, and Diane would make copies of those. I would hope she might send me a copy, and also to you. She also would send copies to the appropriate candidates who have been involved with this challenge. And then I was thinking out loud in my mind that perhaps in the next 10 some odd days or so, you might identify those candidates who will have appropriate notices that need to be made of just what is the universe of things that are financial issues that need to be addressed at all, okay? And this is, for Obley purposes, that is to get the notice together that would be a hearing later on in that, okay?
Gotcha,
Not 10
gotcha.
days to get the hearing done. There's so much already to do, we're
Right.
overwhelmed and all.
Right.
One last thing I will mention is that for the public's purpose and all, understand that when challenges are made, they are jurisdictionally limited. So what we saw was only a portion of the potential challenges that could have been made. Some of the other candidates may find these same deficits in their portfolio, but they were not challenged, okay? So in sort of a fairness and all, those that have been allowed to be qualified, they are sort of standing as surrogates for the people that might have been challenged.
Sure.
So just make that observation, okay?
Right, yes.
Well, if we get bored, we may go poking into some of those other things too, you
Yeah,
know, so.
Well, and my primary concern is, other than the ones that we have to address by a future hearing, is that we get it right going forward. We can't, you can't put toothpaste back in the tube, we understand that, for things that have happened in the past, but we can get it right going forward and stay there. And that's, you know, that's kind of our goal, I believe,
Yes.
for all of us, is, let's tighten up the ship and get it sailing straight. All right, having said that, is there any other comments? Okay. Well,
I have a question, and I think it can be part of this meeting or not. When should we set our next meeting? Because I have a couple other issues not related to these
Right.
things. that need-
When is our next regular meeting scheduled?
The chairman schedules the meetings.
Oh, I thought we had one already. Did we not have one
We've got
already
something
set?
coming up March 21st on the 4th on the public
24th,
test.
that's a public testing.
of the-
Oh, that's the
We have
public
to do-
testing, okay.
Yeah.
Okay, well, I will look at my calendar and confer with both of you and see when that next
All right.
possible date is.
Because I think we need to publish this. I've been asked, when does the election board regularly meet? Because I know a couple of people who would like to hear that.
Right.
And they have a right to, so.
But, right, by law, we only have to, is it two? I think we only have to have 2 meetings a year, but obviously we have more than that. But we will publish it when we have the
Right.
next
We
one.
give 48 hours, at least 48-hour notice is what it is, and normally it's not a regular, because there's times we have to wait to get all the stuff together in order to have it, or else you'll have,
Well, just
Yes.
when we know it, I'll
Yeah.
let people know, because I
And-
do have some interested party who'd like to
Sure.
Okay.
sit in. They're just curious.
And what I'll do, in accord with the attorney's recommendation, I will get with the clerk and identify the specific ones, again, that we mentioned in here, and we will try to form some kind of notice, you know, the wording on the notice that we'll get out to them. I'll run it past
Just-
both of you before we finalize that, and then we can send that. I don't think we have to vote on that particular notice. I think we could just send that
Not at this
notice
time.
out to candidates, because it won't, that's not the actual scheduling of the hearing, it's just letting them know that these things will be coming. Okay, any other business? Okay, with that, then I will entertain a motion to adjourn.
So moved.
And I will second that. All in favor? Aye. We are adjourned.